just share my experience. I'm not going to give you legal advice. So if it is a legal question that comes up, you will hear me say, I'm not an attorney. You all are licensed real estate professionals. You have access to CAR's free legal counsel. If you're not aware of that, CAR, one of the member benefits is that you can call in and get free legal advice for yourself and your client on a typical transaction or a property. So when I tell you that, I'm not trying to deflect it, but I can't give you legal advice. So that's my first disclaimer. Okay, are we good? Bob, you get that? Okay, it's recorded now. I have proof. All right. So today we are going to go through some terminology for foreclosures and TSGs. TSGs means trustee sale guarantee. It's a portion of the foreclosure process that we're going to talk about. All right, so we're going to start by going over some definitions. And again, this is the basics of it. So if you want to tune me out for the next 10 minutes, that's fine. But we need to make sure that we understand what the terms are before we start talking about timeframes, because it will become some acronyms that I'm going to try and slow the process down and give you the names of things so that you understand what we're talking about. All right, so starting out, first thing I want to mention is the deed of trust. When we say it's that there's a mortgage or a loan on the property, we are referencing that there is a deed of trust on the property. So typically your homeowner that is in foreclosure is actually in foreclosure because they have a mortgage on the house and they have missed a payment or 2 or 10, depending on the market that we're in. And Janice is on with us today, Janice Green, because she went through the last foreclosure market with us, and she understands from the sale out, from the REO, which is the real estate owned section out. So we're going to bring her in if you guys have questions about that process. So the deed of trust just says that the homeowner actually owns the property, but they owe on the property. So they're also called a borrower. I know that sounds very easy and redundant, but I wanted to make sure that when we go back and forth between a loan, lien, or a deed of trust, we all understand that it's the same thing. Okay, just a second, another person coming in. All right, so there is, on the deed of trust, there are different parties. We have the borrower, which we just talked about, which is your homeowner typically. We have the trustee, which is the portion of the deed of trust that will perform the foreclosure process should we need one, should they start to miss payments. And then there's the beneficiary, which is the lender. So you will have, let's see, someone's getting some feedback, so I just want to, okay. So the beneficiary is the one that's collecting payments, the one that actually is the loan company. So those are the 3 terms that I really wanted to cover on the deed of trust, and then we're going to go into, and if you have any questions, unmute yourself, ask a question. I am more than happy to take questions as we go along. Okay. So as a title company, if we are doing the title insurance, we are looking for reconveyance to remove the mortgage on the property. So if someone's telling you that they don't owe any money on the property because they own it free and clear, we are looking for what's called a reconveyance. And without a reconveyance, we cannot clear the chain of title or that deed of trust from their chain of title. Junior lien is that second loan or lien. So if they have a first and a second, when we're talking about foreclosures, you always want to ask the question, is it the first or the second that is in foreclosure? So is it the first or the junior loan that's in foreclosure? Because if you think it's the first that's foreclosing, it is a completely different game if it is the second. So you'll always want to specify when you start to work with foreclosure properties, you'll want to verify which loan is in foreclosure. I want to address a quick question on that because someone will ask, what happens if the homeowners association is the one in foreclosure? They would qualify as a junior lien holder. That is something that As a title company, we have seen the homeowners associations actually foreclose on the home, and then they realize, because they didn't know what they were doing, that they have a first and a second on the home, and now they own this house that they are now responsible for making the payments on the first and the second, or even just the first. So again, we stress to the homeowners associations, if you are going to foreclose, you might want to verify how many liens or loans are going to be against that particular property. All right, so moving on, we are jamming through these terms so that we can get to the nuts and the bolts of everything else. So foreclosure is the actual process that terminates the ownership.
I'm watching it, something on Zoom.
From the homeowner from the home. So if they start to fail to make their payments, that process is called a foreclosure, okay? And now we get into the nuts and bolts. Now that we know what a deed of trust is and what a foreclosure stands for, we can start to talk about the actual process. So as we are going through this, I apologize, I keep having to let people in, so I'm distracted. But as we go through this, seriously, if you have a question, feel free to, jump in, put something in the chat. I'll be more than happy to answer them as we go. All right, so the foreclosure process starts when the homeowner misses their first payment. So they are legally in a default situation when they've missed their first payment. Now remember, they have a 15-day window period that they would be considered just late if they made their payment on the 16th, right? So we'll say January 1st, they're scheduled to make their payment. January 15th, they still haven't made their payment. They're still current in the lender's mind or the beneficiary's mind. This is why I wanted to go through some terms before we started talking about this. So they're still current. On January 16th, they have a late payment that comes into effect. So they would have to make their normal payment plus their late payment to bring it current. So they're still somewhat current, they just have a late payment. Now, February 1st rolls around and they didn't make their January 1st payment and they don't make their February payment. Now they're 30 days late and it's reported to the credit reporting agency. So they have a 30-day late. Does that make sense? Can I get a thumbs up from anybody? Does it make sense? Okay. So they have a 30-day late. They literally could start the process of foreclosing after 30 days, but the lenders know that sometimes it's just a fluke, a life situation, something that maybe they couldn't control. So they want to give them another opportunity to redeem themselves. And Marjorie, yes, I have this recorded and I am going to send out the slides. I don't know that I'm going to send the recorded because of the liability it takes on if someone misinterprets it or only listens to half of it. I've just been warned not to really send these out. So I will send the slides. So the notice of default typically wouldn't start until probably 90 days. So they missed January, they missed February, they missed March. And so now they're 90 days behind. And so the lender would then substitute in what's called a trustee. Remember we said the trustee on that deed of trust is one of the three parties we went through in the definition. The trustee is the one that actually does the foreclosure process. So the loan company that's collecting the monthly payment is not geared to actually performing the foreclosure process. So they don't do the foreclosure process. They substitute someone in that clearly knows what they're doing and they know all the legal ramifications for posting, publishing, and notifying the homeowner of their legal rights. So they substitute someone in, they do the notice of default, and that notice of default gets recorded. And so that's when we, as the general public, would have knowledge that that home has gone into the foreclosure process. Now remember, I said they typically wait 90 days before they file that. So they are 3 months behind making payments when we see that first notice of default record. So if you are trying to target these people that are in foreclosure, just know that they are 90 days behind. if you list their home and they still can't make the payments, they could be anywhere between 6, 8, 10, 12 months behind before it closes. So you're going to need to make sure that your net sheet reflects them missing all of those payments. And I highly recommend that if you are going to start targeting notice of defaults, that you are really on top of how much they are behind, because you have legal fees, recording fees, and filing fees that are on top of just the payments, okay? So they missed their payment in January, they missed February, March, and now all of a sudden they do a substitution of trustee and they start the foreclosure process. So that notice of default gets recorded and they have 90 days. There's a 90-day period that that trustee must do certain aspects, publishing it, notifying it. The homeowner must be notified in the first 10 days of that notice of default being recorded, so they get properly notified. They need to publish it in a newspaper. They need to make sure that, you know, everyone that is owed on that property is aware that it's in foreclosure. So 90 days goes by that they've been missing payments, and then there's another 90 days that they had the notice of default. So you're significantly behind when you get to the next stage of foreclosure. And I know I'm going fast, but I'm going to go back through the timeline when we get to the very end of this. So 90 days after that notice of default is recorded, they do this thing called a notice of trustee sale. That is the second stage of the foreclosure process. And so again, if you are targeting notice of defaults and you are going to start going after them to start to list them, because some people will have equity, not all of them will be short sales. So some of them will be have equity, and you just need to know that. And we're going to talk about how to figure that out at the end. But if you get into the notice of default stage, you have that 90-day window period that we talked about where they have to notify, publish, and all of that other stuff. Well, that's great, but typically the homeowner says, we have time. I don't have to worry about it right now. When they start to worry about it is when they get into this stage, this notice of trustee sale stage, because now that gets recorded and they have 20 days before the lender can schedule the auction. So they're in this, oh my gosh, we now have 20 days to get our you-know-what together. And they realize, I better call a real estate agent because I need someone to help me through this process and do it quickly. Well, if they're calling you during that stage of the foreclosure process, the first thing I always say is you better get an authorization to negotiate from them immediately. It's a form that you can get, I believe Margie had mentioned, I think it's in the car contract, authorization to negotiate. If not, I have one that I can send you, because you immediately need to call that lender that's foreclosing and notify them that you have listed the property, you have it on the market, you have an aggressive sales price, and you want to postpone that foreclosure. Now you have become the person that is communicating with the lender the intentions to sell the property as opposed to it going to sale. So if you're in that notice of trustee sale stage, or even in the notice of default stage, and you are the real estate professional handling it, you must have a third-party authorization to negotiate so that you can communicate directly with the lender to tell them the intentions are to sell the property as opposed to for it to go to auction. If you were on my class last week, we talked about doing short sales. Short sales help their credit more than an actual foreclosure does. So if it's not a short sale, great, and it's an equity, you still are going to have those 30, 60, 90-day lates that are going to report, but it's not a complete foreclosure. So when the homeowner says, I'm just going to let it go, one, if they're walking away from equity, what a shame. And two, they're going to also hurt their credit even more. Okay, and I'm not a lender, so I don't know how much it hurts their credits, but I've heard it's 100 points. I don't know. That's just what I heard. So, all right, so they went to the notice of trustee sale stage, and it's that 20 days that they have a waiting period. And so on the 21st day, it could potentially go to sale. meaning it goes to the courthouse steps, an auctioneer calls it, they sell it on the courthouse steps, and then all of a sudden your homeowner no longer owns that property. Hold on just a second, I'm trying to admit somebody else. So they would have lost it at the auction. That day, the property is given to the person that buys it, and then they deal with the process of getting them out of the house, etc., eviction or cash for keys, etc. I do want to mention that we talked about it briefly, postponement. You want to make sure that if you are asking for a postponement that you send them all the paperwork that you can, your listing agreement, proof that it's in the MLS, proof that you're having open houses, virtual, whatever it is that you can send to them to get them to realize that you are sincerely trying to sell the house before it goes to auction, okay? So postponement, you're shooting for that if you're in a foreclosure situation. All right, so once that property goes from the notice of default stage for 90 days, notice of sale for 20 days, it goes to auction, then a trustee's deed upon sale gets issued to the person that buys it at foreclosure. And then it becomes this REO, this real estate owned. And that's when, if nobody buys it, if nobody buys it at the courthouse step and it gets taken back by the bank, that's when it becomes an REO. So if the trustee's sale deed doesn't go to an individual that bought it at the actual courthouse steps or online process, whatever we're doing in today's real market, then it goes back to the bank, and then they have their portfolio that they hire the real estate professionals to do, which is why I have one of them on today in case you have questions about that. A lis pendens is something that is filed by the beneficiary or the lender that says, hey, we're going to start the foreclosure process. That is when it's more of a judicial process. But what we're going through today is a non-judicial. Once in a blue moon, you'll find a beneficiary or a lender out of state that does this lis pendens anyway, just as kind of a secondary cautious way for them to go through the process. So I wanted to mention it to you. There are lis pendens that record against it. It means that there is pending litigation on the property, and until that pending litigation is settled or satisfied, that property cannot sell, okay? All right, the rescission of the notice of default, they do have an opportunity to go in and buy back the property. The likelihood is very small. We did have a period of a while where the foreclosures weren't done properly, or they felt they weren't done properly, so they actually started to have people question whether theirs was done the right way. And so at some point, you're going to hear those things. Reinstatement period, there's people that will file bankruptcy. Oh, hold on just a second, Tanya. How many days will it sit on auction table before it goes back to the bank? If it goes to auction on, we'll say tomorrow is Friday, Tanya. If it goes to auction at 8 o'clock in the morning and it does not sell at the auction because it didn't meet the minimum bid, we're kind of jumping ahead, it goes back to the bank that same day. It doesn't get recalled again a different day. It goes to auction one time and then it gets pulled back and the bank buys it, or the bank owns it. Did I answer your question? I'll wait to see if she answered it. Okay. Oh, hold on. Let's see. Oh, good. Okay. All right. So if you guys are putting questions in the chat, I am going to try to address those. So be aware that if you are dealing with a homeowner and they are trying to stall the process of foreclosure, there are attorneys that are out there that will help them file a bankruptcy to get the postponement of the foreclosure process. So filing a bankruptcy will stall the bankruptcy or the foreclosure process for a little bit, but it's not going to fix it unless they're truly filing bankruptcy and they are willing to negotiate with the bank on how to proceed with a repayment or reorganization, depending on the chapter that they file for bankruptcy. In the last foreclosure process, people were filing bankruptcies so frequently that the bankruptcy courts had decided that they would hear them immediately and immediately disregard them if the bankruptcy paperwork wasn't done correctly, because they could clearly see that they were just trying to stay in their home an extra 2 or 3 months, and they had no way to actually do their debt reorganization. So just be aware, people do try it. Sometimes it works because they truly needed a bankruptcy, and other times they're doing it just as a stall tactic. Can't recommend either way, but it's because I'm not an attorney. Some other terms that you're going to hear through the foreclosure process is a deed in lieu of foreclosure. Your borrower or your homeowner may want to look at that if they don't want to go through the process of foreclosure, or they don't want to deal with the process of actually selling their home. They may want to try a deed in lieu of foreclosure. A little caveat to that is, please know that the bank has to agree to taking the property back in lieu of doing the foreclosure. In the past market, we had people that would get a deed, they would prepare their own deed, then they would deed it back to the bank. The bank does not have to accept that. And most of the time they don't accept that because it's not done properly. So if someone is trying to do a deed in lieu of foreclosure, they still have to work with the bank to get that accomplished. And they contact the bank and they say, we're gonna lose our house, there's no equity. They still have to be able to say why they wanna do a deed in lieu. They just can't go, I'm tired of the house, I just want you to have it back, I'm gonna go get a different one. So a deed in lieu is something that you will run across. I just wanted to make sure you had the terminology. The other couple of things that I wanted to make sure that you understood, trustee sale guarantee is the acronym TSG. It is where a title company gives a report for the foreclosing trustee. The company that's performing the foreclosure hires a title company to prepare a trustee sale guarantee, and it tells them all of the liens or loans that are recorded against the property. So a TSG is a trustee sale guarantee. We give it to the trustee of the actual lender so that they know where they stand as far as in line of creditors. If someone says that they need a lit guarantee or a litigation guarantee, that means that it's a similar report, but we're doing it for a judicial foreclosure. So they're actually going through a court order to reclaim the property as a foreclosure. So the TSG is done when it's a non-judicial, and a lit guarantee is done when it's a judicial. Just a couple of things I wanted to make sure, because when you deal with out-of-state banks, they may ask for a lit guarantee when all in actuality, they probably just need a TSG. Trying to cover the terms. All right, so I'm going to skip this particular slide because I want to go through a different slide with you. I think it's easier to understand. Can you guys see this thing that says foreclosure timeline at the top? Yes? No? Okay, perfect. All right, so delinquency is that time frame where they miss their payments. We talked about not making the payment in January, not making it in February, so now they have a 30-day delinquency. Typically, they wait 90 days because sometimes they have a life event, someone has passed away and you're so distraught you miss a payment, maybe 2, depending on the circumstances. So they typically wait 2 or 3 months. Now, the whole time they're trying to contact the borrower to say, or the homeowner, to say, hey, you know, you missed a payment. Hey, hope things are okay. Hey, we're looking to make sure that you are still out there, you're alive, whatever the circumstances are. That's that delinquency stage. The notice of default stage lasts 90 days. So just because that one delinquency sounded the same, it could be a longer time period. So the notice of default stage lasts a minimum of 90 days. And then after 90 days, they record this notice of trustee sale, and that is 20 days. And on the 21st day, it goes to auction, or it could go to auction. And so what I want to touch on right now is forbearance. We're in that circumstance right now where the government has allowed them to miss payments. So right now, the notice of defaults are not being recorded. So that's to kind of touch on the question that Janice had asked earlier. Right now, they legally can't record notice of defaults against people that are in forbearance. And some people would have already maybe been in delinquency. Then they missed another payment, called it forbearance. And so now they're kind of stuck in that quandary at the lender of, do we record a notice of default? Can we legally do that even though we can't do it because of forbearance? So there's a lot of questions right now of what's going on with the forbearance. Just know that the forbearance started out, I believe, to be 3 months, and that is looking to be extended potentially for a couple of months. So right now, we can't honestly give you an answer to whether the notice of defaults are going to start to record in June or July. It could be July or August. However, there are people that are in foreclosure already. And that was kind of what I was trying to allude to. They've already gone to this stage of foreclosure and the notice of default is already recorded. So let me show you. These properties are in the city of Redlands, and these are properties that are already in foreclosure. And so they're not on market. Most of them are not on market. I didn't, there's a way to search for those that are not on market and on market. This is from a product called Property Radar. I don't get paid to advertise it. I don't get paid to promote it. I do use it to do training. So if you are interested in doing notice of defaults, I'd be more than happy to show you how to utilize the product. It is called Foreclosure Radar, Property Radar. They've kind of changed their names throughout the last 20 years. But it shows a lot of detailed information. So it tells you property address, when it was built, bedrooms, baths, if it was on the market. If it was on the market, it would even tell you who the listing agent was. It does tell you the foreclosure details, when they went into default. It tells you who's actually foreclosing. So this trustee, see this trustee where I'm hovering over? This is that company that's performing the foreclosure process, and this is their phone number. So if you needed to call them, you would call this quality loan service, and you would give them this trustee sale number. See the TS number? So if you were calling to see if you could postpone it, you could call them, give them the trustee sale number, and find out if you could negotiate a postponement. Okay, so the TS number stands for trustee sale number. The trustee is the company that's handling the foreclosure. They may refer you back to the agency or the lender that's collecting the payment still, but you always want to start here because they're the ones that are doing the process for the foreclosure. Okay, so these are properties in Redlands. You can see there are 25 properties, and all I did on this particular search is I went in and I put in Redlands, California. I didn't put in anything else, and I just pulled up the properties that were in the notice of default stage. And just so you know, you can narrow it down by bedrooms and baths. You can narrow it down by ones that only have equity. You could go by a specific lender, but I just left it open so you could see that there are truly homes that are already in foreclosure. And then it does give you an idea of estimated value, what the comps are saying, and then kind of what the sales prices are, so you can kind of get an idea if it's what the sales price would be. So that's Redlands. And then I also ran just so that I could see what the market looked like in Beaumont. We have 34 homes in Beaumont that are actually in foreclosure currently. So this is in the notice of default stage. The same product does the notice of sale stage. So if I wanted to go in and just find the ones that were in foreclosure in the notice of sale stage, I could do the same thing. It looks very similar. It again tells you who the trustee is. It tells you the trustee number and the phone number to call to see when the actual foreclosure is scheduled for auction. So that is Property Radar. We also have a product called Title Pro 247, where you can purchase the leads from, and they are 8 cents a record. This particular product that I'm showing you online is $60 a month. It will do 3 different states. It does California, Arizona, and Nevada. I like it only because it's super easy to use, and this is typically what the investors are looking at. So when you are dealing with people that go to the auctions, this is what they're typically using, is this property radar. So I'm going to stop sharing my screen in case you all have questions, but I do want to touch on, typically someone will say, hey, well, what's next? So now we've talked about the foreclosures, and we've talked about the process and the timeline, and that was basically what we wanted to talk about, was the terminology and timelines of foreclosures. But typically people go, okay, well, now we know it's in foreclosure, then what happens? It goes to auction. So if you're dealing with people that are at the auction, you are dealing most likely with investors. Once in a while, you have a homeowner that wants to buy a property from an auction, and they'll go down to the auction. If you have never been to an auction, you can visit my YouTube page. I take you to a live auction. I used to take groups of people down to the auction, and we would actually sit through a portion of it, and then I had my title underwriter that would explain what you need to look for at the auctions and what questions to ask. But because we can't go out and do anything right now, I'm going to refer you to my YouTube channel, and anybody that's on this particular Zoom, I'm going to send you the PowerPoint, and I'm going to send you the link to the YouTube for the how to buy properties at the auction. But if it doesn't get purchased at the auction, then it becomes an REO property. And I know that Janice Green is on with us today, so I am going to ask her, I'm going to unmute her if I can find her. Oh, she's over here. Oh,
I am muted.
you unmuted yourself. Thank you. So if you have questions about the foreclosure process, the auction process, or the real estate owned, meaning an agent has it listed and how do you go in and buy it, we're here to answer questions. I would be more than happy to take questions via chat. If you want to, you could raise your hand, you can unmute yourself. I know we've gone through a lot of terms today, so please tell me if I didn't make sense. Okay? Do we have questions?
Christy, I actually have a question on Liz pendants.
Okay.
Could a Liz pendants be put on a homeowners association? And if in fact that did occur, does that prevent any homeowner within the association from selling their home?
So you're asking if the homeowners association, if the bank could put a lien on Liz pendants against the homeowners association?
Well, not necessarily even the bank. If there was a Liz pendants against the homeowners association for whatever reason.
Ah, I get where you're coming from. Got it. Okay, so if there's a Liz pendants and it's the homeowners association is being sued, not the homeowner.
Okay.
However, that Liz pendants will show up because there's one, typically it's one of the homeowners that's suing the homeowners association for something, and then it shows up in the chain of title because that same name is on their home, that homeowners association. So we do have to go through the process to make sure that our actual property is not included in that lawsuit or that pending litigation. So we actually pull the pending litigation and we verify what properties are included. And if ours is not included, then we can move forward without anything else for the Liz pendants. That's a great question. Kind of convoluted, but great question. Does that raise any other questions?
I have a question.
Okay.
This is Manny Gonzalez. Hi.
Hi.
So the question I have is in respect to the forbearances, are they pretty standard across per financial institution? What I'm saying, I've heard kind of mixed information between 3 to 6 months, or is it a standard 3 months? And then it's a follow-up question to that is, and for those that are in foreclosure, we expect to see, you know, a waiting period there, not an automatic go to auction perspective. I'm just asking from an investor standpoint.
Yeah, that's a great question, Manny, and I'm glad you asked. We did kind of touch on that. The forbearance was initially set up for a standard like 3 months because we weren't really sure what was going on. They have recently sent out, and it was May 19th. If you'd like, I'll include the letter from the Fannie Mae and Freddie Mac. because we handle Fannie Mae and Freddie Mac in my office for the whole United States. So we deal with them quite frequently. So I'll send you the notice that they sent out that they are potentially extending that forbearance. Now that is just Fannie Mae and Freddie Mac. That is not lender specific. So Fannie Mae and Freddie Mac is conventional financing, not FHA, not VA. So they're considering extending it, and it could be up to 6 months, but they're still in that negotiation period. And then there's that caveat that I have to put out there that some people thought that because they were still making their payments, they weren't in forbearance, but they clicked on and it's happened to thousands of people, they've clicked on the word forbearance in an email that their lender sent to them. And so their lender said, uh-oh, they want to go into forbearance, so they get shipped into forbearance, but their payments are still current. Well, they're being misreported to the credit companies that their home is in forbearance. And so now there's that whole layer of a mess that they're trying to clear up and clean up, and it's going to take months to do that. So I don't personally know, but I have a huge feeling from all of the experts that I'm listening to that we're probably looking at another 3 or 4 months before they can clearly determine, did those people really take advantage of the forbearance, or did they just click on what it was and the lender automatically kicked them into a forbearance status? So if they were already in foreclosure, those notice of defaults that are already showing up, they're already in foreclosure. There is no like, hey, we're going to give you a second chance on forbearance. They were already past their window period. But if they had not filed that notice of default or recorded that notice of default, there's that unknown at the lender right now. So I wish I could give you an honest answer, but I will tell you that there are some really great webinars you could listen to, and I'll send you that Fannie Mae Freddie Mac notice, and then there's a link that you can subscribe to theirs, and that will at least keep you up to date on that.
Thank you so much. Appreciate it.
Welcome. Any other questions?
Well, I'll ask if no one has any. So forbearance, does that in any way affect one's credit negatively?
Yeah, initially the forbearance agreement was you could miss your payments, right? And then all of a sudden they realized, uh-oh, you can't buy or refinance until 12 months after your forbearance period is over, so that they could see that you had 12 months to reestablish credit. Well, now the National Association of Mortgage Bankers, NAM, is like, whoa, wait a minute. We have people that wanted to refinance, and now they can't take advantage of lowering their payments so they could really afford the house now, and then they could continue to make their payments. And so that's how they quickly found out that some people were clicking on the word forbearance in the email from their lender and were being shoved into forbearance when they were still making their payments. So it is negatively affecting their credit worthiness. I don't know the credit score difference, but if they are marked as in forbearance, as of 2 weeks ago, or even 5 days ago, they weren't eligible to buy or refi for 12 months. Now the newest information from Fannie Mae and Freddie Mac says that they're going to look at redoing that so that people don't miss out on refinancing, lowering their payment so that they can continue to afford their home or buy a new home. So that link that I send you has a complete article. It is being worked out. I think it's being voted on this week. So I can't give you an honest answer at this point.
And then in terms of filing a bankruptcy, can they file a bankruptcy within that last 20 days of the foreclosure process? What is the latest time frame they can file?
I've actually had an attorney that's filed their bankruptcy about 2 days before the trustee went to auction, because you can't file it. Well, they say you can't file it so many days in advance because the trustee doesn't get notified fast enough. But this particular bankruptcy attorney is very, very smart and can totally get the trustee notified right away. So I always say it's best to have at least 10 days because you have to file the bankruptcy, you have to have proof of the bankruptcy, and then you have to notify the trustee in time to stop them from sending it to the auction house that's taking it to the county courthouse steps the next day. So it's going to take a process. I say 10 days. Some people say 2. I don't like to bet that last minute kind of thing is going to work out. So I would say 10 days would probably be your safer bet.
Is a forbearance recorded?
No, that's the other problem that we're having because, and I don't think Melissa made it on. I had one of our escrow officers that was going to jump on just in case we had some questions on forbearance. What's happening is that forbearance is just a notice between the borrower and the bank that they're making their payments to. So we don't know, you don't know. We go into a transaction and we're not aware, and the homeowner doesn't realize to say something like, hey, we're in forbearance. And then you've done your net sheet based on them being current, right? And then all of a sudden we get the payoff statement at the very end of a transaction, and it's already happening, by the way. We get the payoff statement at the very end of the transaction. It's like, oh, this property's in forbearance, and they have late payments, and they have 2 payments that they've missed. So it would be great if they filed or recorded a forbearance notification, but I think because it's so new and the government was just trying to get help out to the parties, that they just had an agreement between the bank and the borrower. So we don't see anything recorded in our state. We just see that the last minute on the payoff statement that they are in forbearance. So you might want to ask your homeowners, hey, did you have the opportunity to take advantage of the forbearance? And if so, how many months did you take advantage of it for? And then that way they would hopefully give you the up-to-date information. But they also get a statement from their bank, and their monthly statement may not include the forbearance amount because that comes from a different department. Their monthly statement comes out, and it shows that, this is the approximate payoff, but they don't know that there's forbearance payments that are in a different department. So you definitely want to ask. Okay. All right. Any other questions?
Christy, just yesterday I was reading a article and it's saying that now after forbearance they'll have 3 consecutive payments. So hopefully that was on Mortgage News Daily. I don't know how.
Yeah, I read that too. And then this morning I heard that it hadn't been voted on.
Oh, okay.
But I was hopeful that that's what they're going to be voting on and they're going to pass it so that it's only 3 months. But that's still unfortunate because now we still have people that could literally take advantage of the 3% interest rate. But thank you for mentioning that. And I believe it's in the same notice that I'm sending out to everyone. So it does make mention of it. What was the name of that again, Anna?
It was from Mortgage News Daily.
Okay, because I got it from a different source.
Okay.
I will put that in the notes as well when I send it out to everyone. Thank you for sharing that, hon.
You're welcome.
Because at some point, that's what we're here for, is to share knowledge and to make sure that we're getting the information. So when your homeowners come to you and ask you questions, you have the answers or you have the place to go to look for them. So I'm going to give you an opportunity if you guys have cameras on your computer. These are camera covers. I have them that I can mail out to you. These are privacy. If you guys are not aware of this, when you have your camera open, people can hack in and watch what you're doing at home. Not that they want to watch me because I don't do anything. I have no life. But these camera covers just slide over your camera, and then you can slide them open when you want to have a video conference. If you are interested, I have put my cell phone in the chat. I'd be more than happy to mail it out to you for 1 or 2 cameras at your home. I have about 30 of them. So if you put your, text me your name and your home address, I will pop them in the mail today or tomorrow so that you have them. I seriously want to have you guys covered not just in title, but in safety, because there are people that are out there that they have plenty of time on their hands to watch you do whatever it is that you do in your own home. Oh, and Marjorie says she even has one on her phone. So there you go.
Nice.
All right, so I'm going to open it up to any last minute questions. I see you, Janice. I will make sure. I do have, again, this PowerPoint that I will be sending out. I'll be sending out a couple of links. If you have questions, seriously, I know I say this in every post I put, but I'm truly here to help. If I don't answer your phone call, it's because I'm either with somebody or I'm doing this or I'm in an office, not right now, but I'm in an office and I don't necessarily want to talk about your questions or concerns in front of somebody else. But my guarantee is I always call you back that same day. If you need something that's urgent, it would be even better if you text or email me, because while I'm sitting in a meeting, I sometimes can text and email a response faster than me getting on the phone with you. So if you guys don't have any other questions, I have completely enjoyed seeing all your lovely faces today. And those of you that did
Thank you so much.
I will see you soon, hopefully. All right, guys.
Thank you, Christy. That was very, very informational.
Thank you. I appreciate you coming. Good to see you guys. Hope to see you
Bye.
soon. All right. Bye.